would like to invite our good friend Mr. Lourdu Maurya, who is going to give a detailed lecture on the Passport Act today. I have learned through our good friend Mr. Manigandan that he is practicing at Madras High Court and its bench at Madurai. I have further learned that he is specialized in service law, and he can proudly say that he is a junior of Additional Solicitor General of India, Mr. G. Rajagopal. I don't want to take much of his time. I would like to request Mr. Maurya to give his detailed lecture on the subject of Indian Passport Act. Thank you for giving me an opportunity to invite Mr. Maurya.
Maurya, the floor is yours now.
Good evening, friends. Today, we are going to have a discussion on the Passport Act with special reference to the powers of the authority to refuse and impound passport. Before we go into this topic, it is necessary to trace the history of the enactment, namely the Passport Act 1967. Prior to the decision of the Honorable Supreme Court in the case of Satwan Singh Sahani versus Union of India, which is reported in AAR 1967 Supreme Court 1836. This is the first judgment which came before the enactment. This is AAR 1967 Supreme Court 1836. This judgment paved the way for the enactment of the Passport Act 1967, because during that period there was no law regulating the issuance of passport. Therefore, in this case, when the Supreme Court was called upon to decide the action of the government in impounding the passport of the petitioner, the majority judges held that right to travel abroad is a part of a person's personal liberty of which he could not be deprived except according to the procedure established by law in terms of Article 21 of the Constitution. And since there was no law establishing such procedure at that point of time, the Supreme Court held that government had no right to refuse a passport to any person who might have applied for the same. The majority also held that government's claim for absolute discretion in the matter of issuance of passport would be violative of Article 14 of the Constitution. Therefore, in this scenario, the government urgently decided that there should be some law to regulate the procedure for issuance of passport, as a consequence of which an ordinance, namely the Passport Ordinance 1967, was promulgated by the President of India, because during that time the Parliament was not in session. Subsequently, to replace the ordinance of 1967, the Passport Bill was introduced in the Parliament, and the same received the assent of the President and came in the statute books as the Passport Act 1967. Friends, when we all speak about the Passport Act, the first judgment which strikes our memory is the famous Srimati Menaka Gandhi's case, reported in AAR 1978 Supreme Court, page 597. AAR 1978 Supreme Court, 597. In this case, the petitioner's passport was impounded by an order of the central government, and the reasons for impounding the same were not furnished. Friends, remember, this case arose in a period following the end of the national emergency in India. Therefore, the government during that period turned down the request of the petitioner, seeking the reasons as to why the order had been passed, stating that it was in the interest of general public. Therefore, the petitioner was not in a position to know what was the exact reasons why a passport was impounded. This prompted the petitioner to challenge the passport impounding order of the central government and its subsequent refusal to provide reasons for the same before the Honorable Supreme Court under Article 32 of the Constitution. Friends, it is very interesting to note here that though the Passport Act 1967 provides for a statutory appeal under Section 11, the petitioner in that case was not in a position to exercise the statutory appeal because the passport authority which impounded the passport was the central government. Friends, before I go into the topic, I would briefly, I think you will be having the Passport Act with you. In the Passport Act, if you refer to Section 2C, the passport authority means it's defined as an officer or authority empowered under rules made under this act to issue passport or travel document and includes the central government. Now, a quick reference to the appeal provision, that is Section 11. In that section, it is clearly specified that any person aggrieved by an order of the passport authority under Clause B or Clause C of subsection 2 of Section 5 or Clause B of proviso to Section 7 or subsection 1 of 3 of Section 10. Section 10 deals with impounding. I will take you to that later. Or by an authority under subsection 6 of Section 10 to whom the passport is subordinate may prefer an appeal against that order to such authority and within such period as may prescribe. Now, if you go to the proviso, it specifically states that provided no appeal shall lie against any order made by the central government. Now, in this case, quite interestingly, the central government had directly impounded the passport. Therefore, the petitioner was not in a position to exercise a statutory appeal under Section 11. And the Supreme Court in that case held that the provisions of natural justice should have to be read into the particular section, namely the substantive provision of law, which deals with impounding of passport, namely Section 10. If you go through Section 10, it only gives as to how the passport authority is empowered to impound passport and the grounds are specified. But if you carefully go through the provisions, the principles of natural justice, there is no reference. But if you go through Section 11 of the Act, if you go through Section 11, subclause 5 and the subsequent provision, it says, the proviso says, provided that no appeal shall be disposed of unless the appellant has been given a reasonable opportunity of representing this case. Therefore, what I am trying to say was, this was the first case wherein the principles of natural justice, though not provided in the statute, was specifically read into by the Supreme Court. Though the Supreme Court held that the right to travel abroad is a fundamental aspect and it is covered within the sweep of Article 21, the Supreme Court did not pass any formal order because the government, through its Attorney General, had gave an undertaking that sufficient opportunity would be provided to the petitioner before passing any order. Now, the next question which I am going to deal is as to whether a passport authority can refuse issuance of passport under section 6 on the premise of pendency of FIR. Friends, this is very crucial. One should understand the distinction between FIR filed against the concerned parties and charge sheet filed. There's a difference between that, because if you read to the provisions of the Act for impounding and for refusal of passport, if you take section 6 of the Act, section 6 subclause F says, it deals with the refusal of passport, and it says that the passport authority can refuse to issue passport if proceedings, clause F, it says, proceedings in respect of an offense alleged to have been committed by the applicant are pending before a criminal court in India. Now one has to carefully examine as to when a criminal case is said to be pending before a court. So I had an occasion to deal with a case wherein most of my clients who had not participated in the Kudangulam agitation, against them, a lot of innocent youth were roped in the Kudangulam agitation cases, and FIRs were filed against them. Therefore, when they had applied for passport, the passport authorities had issued them a show cause notice saying as to how they had suppressed the pendency of criminal case in their passport application. Normally, when you submit a passport application, there will be a clause in the passport application which will ask you to give an undertaking as to whether a criminal case is pending against you. In this case, since no summons were issued against these petitioners, they had simply replied saying no. Therefore, the passport authorities had issued a show cause notice saying that since FIRs were filed against them, they had received an adverse police verification report saying that criminal case is pending, and therefore passport cannot be issued to them. These petitioners had issued an explanation saying that no summons had been issued by any court, and therefore the question of criminal case pending will not arise. In these situations, though they had sent the explanation, the passport authorities refused to consider the applications for issuance of passport. This prompted the petitioner to file a writ petition before the Honorable Madurai Bench of Madras High Court, seeking a mandamus, seeking a direction to issue passport. This case, for your reference, it is reported in 2014, 8 MLJ, page 61. I repeat, it is 2014, 8 MLJ, page 61, and the equivalent citation in CWC is 2014, 2 CWC, page 684. I repeat, 2014, 2 CWC, page 684. In the case of W. Jayhar William and others versus State. In this case, the core question that the court was called upon to decide was whether the passport authorities are right in refusing to issue passport on the mere pendency of FIR. Friends, now it is very important to read the provisions of the CRPC. If we go to the relevant provisions of the CRPC, particularly section 190, section 190 covers the field with respect to cognizance of offense by magistrate. Section 190, it deals with the three contingencies under which the magistrate can take cognizance of an offense. The three contingencies specified in section 190 are: 1. A. Upon receiving a complaint of facts which constitute an offense. B. Upon a police report of such facts. Upon a police report means upon filing of charge sheet. This you will be very well knowing. 3. Upon information received from any person other than a police officer and upon his own knowledge that such offense has been committed. So therefore, a magistrate to take cognizance of an offense, he has to either receive a complaint of facts under clause A or a charge sheet filed by the police clause B or upon information received from any person. Now, let us take a case where a magistrate receives a charge sheet from the police. Sometimes the police people, they directly file the charge sheet, and sometimes the magistrate may return the charge sheet because it may not be in order. So in that situation, it cannot be construed that a charge sheet is pending before a court and a charge sheet is filed and the court has taken cognizance. Cognizance in criminal parlance indicates that the charge sheet should be in order. Charge sheet should be in order means it should have been filed in the court together with all the annexures supplied to the accused. Only in that situation, you can say that a charge sheet is pending. Charge sheet has been filed. This view has been taken by the Andhra Pradesh High Court in the case of Madhumari Chinna Venkat Reddy. Madhumari Chinna Venkat Reddy was a state of Andhra Pradesh, reported in 1994 Criminal Law Journal, page 257. 1994 Criminal Law Journal, page 257. In this case, the Andhra Pradesh High Court held that until the charge sheet has been filed in the court, together with all the annexures supplied to the accused, you cannot say that a charge sheet has been filed and it is complete. Now, let us take a case where a magistrate receives a complaint under clause A of the section 190. Even in that situation, if the magistrate, without applying the mind to the facts of the case, directs the police to investigate the matter, even in that situation, a criminal case is not generated for the purpose of section 6 clause F of the Passport Act, because section 6 is very clear. Section 6F clearly mandates that only when a criminal case is pending before any court of law. Therefore, in this case, which came up before the Madurai bench, my argument was that only FIRs were filed and no charge sheet has been filed before the court. Therefore, the court could not have taken cognizance of the offense. Moreover, my clients did not receive any summons from the court to appear before the concerned judicial court. Now, there was a decision of the Calcutta High Court in the case of Kamal Kumar Natokam Dash Parekh versus Superintendent Regional Passport Office, reported in CDJ 2010, Calcutta High Court 344. See, I repeat, CDJ 2010, Calcutta High Court, page 344. In this case, a criminal case was registered against a petitioner for offences under various sections of IPC in connection with the allegations of artificial rising of share prices. The petitioner was a president of the Calcutta Stock Exchange and he was arrested in connection with these offences and later released on bail. And when his application for passport was not considered, he approached the High Court, and before the High Court, the core question was the petitioner was arrested and released on bail, and therefore the passport authorities had refused to issue passport, saying that criminal case was pending. Even in that case, the Calcutta High Court held that mere arrest and releasing on bail in the course of the investigation cannot mean that a criminal case is pending, and only when the charge sheet has been filed and the judicial magistrate take cognizance of the offence under the relevant provisions of CRPC, and only when the judicial magistrate applies his mind and issues summons under the CRPC, you can say a criminal case is pending. And the Calcutta High Court issued a direction to the passport authority to release the passport to the petitioner. Now, there was yet another case wherein the passport was issued for a period of 1 year. Normally, if you go through the Passport Act, the relevant statutory provision which deals with duration of passport is section 7. Section 7 says a passport or travel document shall, unless revoked earlier, continue in force for such period as may be prescribed, and different periods may be prescribed for different class of passports or travel documents or for different categories of passport. Now, if you read section 7 along with rules, the relevant rule is rule 12 of the Passport Rules 1980. It specifically mandates that an ordinary passport for persons other than children below the age of 15 years should be issued for a period of 10 years. Therefore, normally a passport will be issued for a period of 10 years. But in this case, which I am going to deal, the passport was issued for a period of 1 year. The reason the passport authorities cited that a criminal case was pending. Actually, the facts were they had directed the petitioner to approach the concerned judicial magistrate for getting permission to travel abroad. This is because normally when a criminal case is pending, you can't directly refuse issuance of passport. The central government has issued a notification exercising its powers under the Act. If you go through the provisions of the Act, there is a provision, specific provision, which deals with the power of the central government to accept the class of people who had against whom criminal case is pending. So therefore, exercising powers under the Act, the central government had issued a notification based on which this notification
Maurya was disconnected. He'll join again, I think.
the notification which I was dealing is with the notification issued by the Ministry of External Affairs in GSR number 570E dated 25/8/1993. This notification dealt with the exemptions and conditions with regard to issuance of passport and permission to travel abroad to citizens against whom proceedings are pending before a criminal court. This notification basically mandated that the applicant against whom a criminal case is pending has to approach the concerned court and get and file an application to travel abroad. Therefore, based on the direction issued by the concerned magistrate court, he has to approach the passport authorities, and the passport authorities will consider this application for issuance of passport. In this case, which I had the case now which I am going to highlight is the decision of the Madurai bench of Madras High Court in the case of Sharath versus passport officer. This case is reported in. It is an order passed by the Madurai bench, and the question which came up for consideration was whether the passport authority was right in directing the petitioner to approach the judicial magistrate for issuance of passport. The judgment is reported in it is the I will just pass on the citation later. It is reported in MLJ and CTC. It is in the case of Shiva Sharath versus passport officer. This case is quite similar to the case I already discussed with you. The facts are almost similar. This is a case wherein the petitioner was unnecessarily roped in to Skudangulam agitation, and again his passport was impounded, and a showcase notice was already issued to him as to why his passport, why he has given a wrong information regarding the pendency of criminal case. Therefore, when he had approached the passport authorities, they had directed him to approach the concerned judicial magistrate, and the petitioner had approached the judicial magistrate court in Lourdu, and he had sought a direction for issuance of passport and permission to travel abroad. Quite interestingly, in this case, the judicial magistrate directed the passport authority to issue passport without specifying the period. The period was not specified, and she, with the condition that the petitioner should get permission from the court, that is the judicial magistrate Lourdu, before traveling abroad. And subsequently, when the petitioner had approached the passport authorities had issued passport for a limited period of 1 year. Now, when the petitioner was actually, that passport was of no use to him because he had got a opportunity to work abroad, and the visa, the employer demanded that only if the passport is for the normal validity period of 10 years, then he will be given the job. This prompted the petitioner to approach the Madurai bench of Madras High Court, and the question there was whether the passport authorities were right in issuing the passport for a limited period of 1 year. There again, the relevant statutory provision which governs the facts of the case was section 62F. 62F, as I already pointed out, is as to whether when a criminal case is pending. 62F specifically mandates that a criminal case is said to be pending. At the risk of repetition, I repeat that the criminal case, the passport proceedings in respect, clause F says, proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India. Therefore, again, the question was whether mere pendency of FIR, whether can you say a criminal case is pending, and whether the notification of the Ministry of External Affairs will be applicable, and whether the petitioner should approach the judicial magistrate court for obtaining permission. The court said, right or wrong, the petitioner approached the magistrate court, but anyway, the notification cannot be applied to the petitioner since it was a case of mere pendency of FIR, and the court directed the passport authorities to issue the passport to the petitioner. Now, yet another case which is which also deals with almost similar facts is a decision of our High Court. This is not reported. It is in the case of Mrs. Kushbu Sundar versus Regional Passport Authorities. The writ petition number is 47 of 2017. In this case, the petitioner had applied for reissue of passport with fresh pages since pages in a passport got exhausted. This is not a case of reissuance of passport after the validity period has expired, but this is a peculiar case wherein in the passport book all the pages got exhausted. Therefore, the petitioner had applied to the passport authorities for reissuance of passport with fresh pages. Actually, the validity was until 8/3/2022. But the passport authorities had taken a stand that the petitioner, as you very well know, was during that crucial point of time had joined a political party, and she was a star campaigner during those elections. And in the course of the campaign, certain criminal cases were registered against her. Therefore, the passport authorities had refused to issue passport, citing that criminal cases were pending against the petitioner. Of course, the petitioner had approached the High Court by filing quash petitions, and she had got a stay of all the cases filed against her. Now, the question which came up for the consideration before the Honorable High Court was the application of Section 62F. Now, if you go through the relevant provisions, which I would like to point out here that this is a case where the petitioner's passport was returned, saying that criminal case was pending under Section 62F. Again, they refer to Section 62F. But if you take Section 62F, it deals with refusal of passport and travel document. Here in this case, the petitioner already had a passport with her, and the validity was until 2022, and therefore an argument was raised before the High Court that it is not a case of issuance of fresh passport or reissue of passport under Section 6. Therefore, the passport authorities were not right in resorting to Section 62F. Now, again, as per the relevant facts, passport authorities in that case had not resorted to Section 10 for impounding the passport. Therefore, they in the counter affidavit before the High Court, they very well said that they had not taken any steps for impounding the passport, but they specifically referred to Section 62F and said that criminal case is pending. Therefore, they cannot reissue the passport with fresh pages. The Madras High Court had specifically held in that case that the passport authorities can only take resort to Section 10. Section 10, if you go through the provision, Section 10 says the passport authority may, having regard to the provisions of subsection 1 of Section 6 or any notification under Section 19, vary or cancel the endorsement on the passport or travel document with the previous approval of the central government, subject to which a passport or travel document has been issued, and may for that purpose require the holder of the passport by notice in writing to deliver up the passport or travel document. Therefore, according to Section 10, if the applicant had already a passport, if the passport authorities can only under Section 10(1) cancel the endorsement, or they can impound the passport for various grounds for saying that criminal case is pending. Therefore, even as per the facts of this case, the petitioner had already got a stay of all the criminal cases, and therefore the Madras High Court gave a direction to the passport authorities to process the application of the petitioner for reissuance of fresh pages, but with the condition that the petitioner approaches the Madurai bench and gets permission to travel abroad. This is because the criminal cases, another question which I like to say is with regard to the notification, which I already specified. The notification which I already said mandates that with respect, if a criminal case is pending, the concerned applicant against whom a criminal case is pending has to approach the concerned judicial magistrate court before for getting permission to go abroad. Now, let's assume, as even in this case, the petitioner had got a stay of the all the cases filed against her. Therefore, when the concerned applicant gets a stay of all the criminal cases filed against her, then the applicant need not approach the concerned magistrate court, because all the proceedings before the concerned lower court has been stayed by a high court. Therefore, the concerned courts get transferred to the high court. Therefore, the applicants have to approach the concerned high court, which had stayed the matter, by filing a writ petition for getting permission to go abroad. This, even I had an occasion to deal with a similar case, which I would also I will circulate it later. It is again a case where the passport was actually impounded. It was a recent case. Passport was actually impounded by the passport authorities, citing that the criminal cases were pending against the petitioner. It was also a case involving Kodangalam agitation, wherein FIR was filed and subsequently charge sheet was also laid before the concerned magistrate. Subsequently, I had moved the Madurai bench and got a stay of all the cases filed against the petitioner, and subsequently I moved the Madurai bench seeking a direction for handing over the passport to the petitioner. So the question which arose, the central government pleader there took a specific objection, saying that it is only a case of stay, and therefore it is only a temporary stay, therefore passport cannot be released to the petitioner. And again I relied on there was yet another decision of the Madras High Court, saying that even if stay is granted by the High Court, by way of the notification issued by the Ministry of External Affairs, the petitioner can very well approach the concerned court and get permission, based on which the passport authorities have to consider issuing passport. Therefore, in that case, the central government pleader said that I have to approach the concerned judicial magistrate court. But apparently, in that case, as I already told you, all the cases filed against the petitioner had been stayed by the Madurai bench, and therefore, when I produced the interim orders passed by the Madurai bench, the Madurai bench was going to the Madurai bench passed an order again tracing the very same notification, recording the notification, and by imposing certain conditions, the passport was released to the petitioner. It was a case. The causative of the case is Jennifer William versus passport officer. And now I come to the next question. The next question which I am going to deal is as to who can impound the passport. Actually, a lot of contradictory views have been by various high courts, and the first judgment of the Honorable Supreme Court, which has been followed till date, is a decision of the Honorable Supreme Court in Suresh Nanda versus Union of India. This is a case reported in 2008, 3 SEC, page 674. I repeat, it is 2008, volume 3 SEC, page 674. This is a case wherein the petitioner's passport was seized and detained by the CBI special judge for certain inquiry. The petitioner had approached the special judge for release of passport. The special judge of CBI released the passport on imposing certain conditions. The CBI immediately approached the High Court by filing a criminal revision, and the High Court reversed the order of the special judge and refused to release the passport and impounded the passport. Therefore, the petitioner had approached the Honorable Supreme Court by filing SLP, and the question which arose for consideration was as to whether the CBI court was right in impounding the passport. Now, the provisions which was relied by the learned ASG appearing before the Honorable Supreme Court was Section 102 CRPC read with Section 165 CRPC read with Section 104 CRPC. Section 102 deals with the powers of the police. 165 deals with search and seizure, and Section 104 deals with the power of any court to impound any document. Now, the question which the Supreme Court was called upon to decide was that any document any document under Section 104 includes passport. The Supreme Court held that when there's a special act covering the field, namely the Passport Act 1967, and when there's a specific provision empowering the passport authority to impound the passport, the Supreme Court held that no court has power to impound passport, though the provisions of CRPC provide that the court may impound any document. Quite interestingly, various other high courts subsequently have taken a different view. In fact, our high court was called upon to decide as to whether debt recovery tribunal has a power to impose travel restraints on a borrower in the interest of justice. In the case of ICICI Bank versus DRT, reported in 2011, 6 CTC, page 70. I repeat, 2011, volume 6, CTC, page 70. The division bench of the Madras High Court held that the Debt Recovery Tribunal, in exercise of the powers conferred under subsection 25 of section 19 of the recovery of to pass orders directing surrender of passport. The division bench held that both enactments, namely the Passport Act and the Recovery of Debts Due to Banks Act, operate on different fields, and the powers conferred on the tribunal to pass interim orders, particularly under section 19, clause 25 of the Act, is wide enough to cover the power to pass an order directing surrender of passport. Section 19, subsection 25 empowers the tribunal to make such orders and give such direction as may be necessary to expedite, to give effect to its orders, or prevent abuse, or to secure justice. Therefore, the division bench of the Madras High Court held that the DRT was right in impounding the passport. However, a contradictory view was taken by the Karnataka versus Passport Officer, reported in AR 2002 Karnataka 118. I repeat, it is AR 2002 Karnataka, page 118, wherein it was held that financial institution cannot maintain writ petition seeking a direction to the passport authority. So facts are quite different. The case that arose before the Madras High Court was a case where the DRT had impounded the passport. This is a case where the financial institution, namely ICICI Bank, had approached the passport authorities to impound the passport of certain borrowers who had defaulted repayment. Since the passport authorities had slept over their application representation, they had moved a writ petition before the Karnataka High Court, and the Karnataka High Court held that the provisions of Section 10(3)(h) of the Passport Act cannot be invoked for preventing the departure of a passport holder by impounding the same from the country is likely to affect the financial interest of the financial institution. It was held that the notice issued by DRT for the presence or appearance before the tribunal cannot be construed as summons or warrant while interpreting Section 10(3)(h). It is also relevant to note that the Delhi High Court has also addressed the issue of impounding of passport from and also restraint from traveling abroad by DRT. The Honorable Delhi High Court has consistently held in various judgments of the held that the debt recovery tribunals are not empowered to restrain a borrower from traveling abroad. To be brief, there are certain decisions of the Delhi High Court, that is in the case of A.S. Mittal versus Debt Recovery Tribunal, reported in 2004, 121, Company Cases 309, Delhi. I repeat, 2004, 121, Company Cases, page 309, Delhi. And the second case is Gurbachan Singh Saluja versus DRT. This is in fact an unreported decision. The writ petition number is Writ Petition Civil 12030 of 2009. Therefore, conflicting views has been taken by different high courts in the issue of impounding of passports by DRT. However, very recently, the Honorable Supreme Court has held that Enforcement Directorate has no power to impound passport. In fact, the Supreme Court had passed this order following the decision of the Honorable Supreme Court in the case of Suresh Nanda versus CBI, which I have already cited before you. That was the first case which I cited, saying that CBI court has no power to impound passport. The decision of the Honorable Supreme Court following this is in the case of Assistant Director Enforcement Directorate versus Ashok Ramachandra Chugani and another. It is not reported yet. It is Assistant Director Enforcement Directorate versus Ashok Ramachandra Chugani and another in criminal appeal number 1674 of 2020. Friends, with this, I conclude my session, and as far as I have shared my experiences regarding the cases which I have dealt with, and the important point which I am focusing is, normally in most of the cases, if a person applies for passport, the passport authorities, when they go for this police verification, the police verification, the local police, in case if a FIR is pending, they send an adverse police verification report to the passport authority, and the passport authority mechanically, without getting the exact details of the case, they reject your passport application. In fact, if subsequently you apply for renewal, and if they get an adverse police verification report, they issue a show cause notice as to why you have suppressed the pendency of criminal case. Now, the conclusion which I am at the end of the session, the conclusion which I am conclusion which I want to conclude is merely because an FIR is pending, one cannot say that a criminal case is pending, and passport authorities cannot mechanically reject the passport. With this,
And